And so the statute still applies there.
I suppose that YouTube could display these thumbnails purely at random. But if it does anything than displaying them purely at random, isn't it organizing and presenting information to people who access YouTube?
Yes, but that doesn't put it within the scope of the statute.
Well, does that constitute publishing?
Yes. So they would be publishing. They would be publishing the thumbnail.
Right.
But if the thumbnail isn't itself, if the way they're using it is encouraging people to engage.
Well, that's a different question, though, isn't it? I don't know where you're drawing the line. That's the problem.
Oh, I see.
That's the problem that I see.
Oh,
Unless you're saying that the publication requirement is satisfied under all circumstances, unless the thumbnails are presented purely at random.
It's publication even if it's at random, but the injury in the hypothetical we're talking about ISIS doesn't follow from the content of the thumbnail. The thumbnail would typically be fairly benign. The harm comes.
Yeah, but in every instance, in those instances where the thumbnail is benign, that's not a concern for purposes of this case. But in all those instances where some plaintiff might have some cause of action based on the content of the video that has been posted,
there would have to be a cause of action, as we assert there is in JASTA, for encouraging people to go look at the video. That's a fairly uncommon form of cause of action. The cause of action, insofar as the plaintiff asserts a cause of action based on the video itself, that you've been sent to, that's within the scope of the defense.